I'm Gerald Maggio, California divorce mediator, licensed divorce attorney, and founder of California Divorce Mediators, where we offer people an alternative to traditional litigation by offering an amicable, lower cost, and reasonable way to resolve your case out of court. In this video, I'm going to answer some of the frequently asked questions regarding the mediation process so that people can make an informed decision before they decide to proceed with divorce mediation. Number one, how does divorce differ from traditional divorce litigation? The biggest issue between divorce mediation and traditional divorce is that in a traditional divorce, a judge makes a decision on what the resolution of your case issues are. Whereas in a divorce mediation and family law setting, a divorce mediator helps broker a resolution that lets you and your spouse resolve the issues out of court and control the outcome of your case. Number two, when is mediation a good option? Mediation is a good option where both parties are willing to compromise, have open communications, and are transparent with each other and able to talk amicably to try to resolve issues, but are willing to compromise on that process to get there and get a full resolution. Number three, how long does a typical divorce mediation or family law mediation take? The duration of a divorce mediation can vary depending on the speed of the parties and desire for the parties to get the case done. Depends on the complexity of the issues, how many mediation sessions end up being necessary, and other factors that can affect the duration of a mediation. But generally, most mediations can be completed within 3 or 6 months, sometimes longer. But again, it really depends on how motivated the parties are to get things settled in order to get the requirements before the mediation sessions even starting. Number four, will I still need an attorney if I'm going through the divorce mediation process? That's a good question. While a mediator can provide legal information, it's generally advisable for parties to get at least legal advice from an independent attorney about their situation, and usually in particular to have them review the final proposed marital settlement agreement as part of the final judgment that is generally worked on in mediation to make sure they understand it, they understand the rights before they sign off on that. So it's not a requirement that the parties do that, but it's advisable that they do. It's their option if they chose not to do so, because a lot of people are looking to save money in the mediation process. They don't have to, but it's certainly advisable to do so. Number five, how much does mediation cost? At California Divorce Mediators, we use an all-inclusive flat fee retainer, and we can advise you when you contact us of what those costs are depending on the circumstances of your particular situation. But without a doubt, divorce and family law mediation is always generally a better option in terms of cost effectiveness versus traditional litigation, hands down. Number six, is mediation confidential? The answer is yes. Mediations are confidential. Anything that's discussed and worked out in mediation is confidential. So none of the discussions and negotiations that are done in mediation can be revealed in court. They are not to be disclosed by the parties and cannot be used for any purpose in a court litigation. So the only thing that would be disclosed from a mediation would be your final marital settlement agreement, which has to be filed with the court. So generally that information in terms of your final settlement is filed with the court. But other than that, the whole process is otherwise entirely confidential. Number seven, what happens if we can't agree on everything? That's not unusual. That's what mediation is there for. A mediator will help work through the disagreements to hopefully come up with a full global settlement, which is a complete settlement. If after strong attempts to try to come to resolution on those other issues that cannot be resolved, it's possible to draft up a partial agreement on the issues that the parties do agree on and may have to go litigate the other issues. It depends on the circumstances. In our experience, we generally settle 90-95% of cases, all issues in a divorce mediation. So it's rather rare that parties end up having to go to court to litigate an issue. Number eight, can mediation resolve emotional and communication issues? Yes, to some extent. Mediation can help parties to address issues regarding emotional issues and communication problems. It's not a replacement for therapy, but it can at least establish some guidelines and problem-solving skills that will hopefully allow the parties to be able to address other issues once those underlying maybe emotional or communication problems have been dealt with first. If you and your spouse are looking for an amicable, lower cost way to resolve your case out of court, feel free to contact us at California Divorce Mediators, where we can tell you the next steps on how to proceed with resolving your case out of court through divorce mediation. If you like this video, feel free to subscribe to our YouTube channel at the end of this video for more helpful information about divorce and family law issues. See you next time.